for the night and all that. There is this case going on at the Supreme Court. It's Hamani versus, I guess it's U.S. versus Hamani, and what this case is about is whether when you purchase a gun, on the application to purchase a gun, no matter really what state you're in, it says, are you an unlawful user of marijuana? And so it's the unlawful part of the statement that is in question, because in many states, as you know, it's well legal. Right. So the question becomes this: if you are a medical patient, or you're legally using cannabis in a state, should you be prohibited from owning a gun?
Well, point of reference, I had a friend in Florida who was a medical patient, and they're not able to hold a gun, or they're not able to carry, weren't able to carry holding their medical card.
Right.
That's already a precedent in a lot of places, and I think.
But in some states, it's not. Some states, yes, there are people who hold medical cards and a license to carry. Now, we're not even necessarily talking license to carry. What we're talking about is whether you can just legally own a firearm.
So my answer to this would be, we categorize guns very differently for domestic violence. People with histories of domestic violence in some states. There are many different places where we look at guns case by case, which I think it absolutely should be. And I think a background check, you look at that person's history, you weigh up, have they been doing other illicit drugs? Do they have other mental health issues or anything serious going on in their head?
No, I agree with you. There should be some level of review. I get this. Don't get me wrong. But I think at the core of the item, at the core of the issue, I should say, at the core of the issue is whether that's unconstitutional. Meaning, if you're not a convicted felon, you as an American citizen have a right to exercise your Second Amendment right and own a firearm.
So not the prospect, but as it's written.
So people are lying on these applications to obviously not, they want to be able to participate in it, so they lie. But the question becomes, should they have to lie? And so I came across a video of a guy who I watch, because I watch this stuff sometimes. His name is Coleon Noir, and that's not his real name. That's his name on air, and he's been doing content in the gun space forever. So he did a video of, and I guess I'm going to control room. I'm going to ask you, either if you put it up on the main screen, keep us up on the screen, or put it on the back screen. I'm going to ask you to stop, but he does a really good 5-minute piece, and we're going to stop it along the way and talk about it. He does a really good job summarizing what's actually going on, and this is whether you smoke pot, don't smoke pot, whatever. And it also, we'll just start playing the video, and then we'll take it from there. So go ahead, give it a roll.
The federal government says you can lose your gun rights. Don't take my word for it. Listen.
What if he took one gummy bear with a medical prescription in Colorado? You don't even need that anymore. But let's say he had one to help him sleep every other day. Disarm him for life?
No, it's not disarm for life, and here's what's going
Potentially.
on.
Would that be enough under your theory? One gummy bear every other night with a medical prescription.
So I think you'd have a potential rehave problem, but I will accept the hypothetical. So let me just deal with
I think
what's
the
an
answer is
unlawful
yes,
user.
under the government's theory.
Yes, under our theory, but let me give you
Yes, under our theory, that qualifies. That's the United States government arguing before the Supreme Court. This is United States v. Hamani.
All right, so what I found fascinating about this video is that there's audio of this interaction. Like, there's audio coming out of the Supreme Court, these oral arguments.
Right.
And so what I find fascinating is that the Supreme Court justice is saying, are you saying that somebody who simply takes a gummy bear 2 nights a week for sleep purposes would fall under your fucking, idea of someone who's an unlawful user and someone who's unconstitutionally allowed to possess a firearm?
Which, let's note, for someone of their stature, that's a very informed question for them to ask, and that's a good, it's not like a uninformed question that they're not taking seriously about looking at this law. Like, he stated one gummy for sleep purposes, so he knows that there's implications for this. So I think that alone is at least they're putting thought into it on some serious regard.
But yet the U.S. Attorney, district attorney, or whoever the hell's making this argument is saying, yes, that would fall under our theory. So let's keep playing it.
I wish to add a note here.
Challenge is 18
And
U.S.C.
that is-
922 G3, passed in 1968. It says if you're an unlawful user of a controlled substance, you can't possess a firearm. Felony, up to 15 years in prison. That's what we're talking about. Now listen to how they justify it.
Unlike alcohol, illegal drugs are illegal. They're illegal because Congress deemed their use dangerous at any level.
Dangerous at any level. Not dangerous with a gun, not dangerous while committing a crime. Dangerous at any level. So Congress labels something illegal, and that automatically makes you too dangerous to exercise a constitutional right. That's the theory. Now
Pause.
it gets clear.
So, immediately, I just want to say that looking at this already, obviously
Mike.
we have more to look at. Obviously, we have more to listen to about this, but immediately I'm thinking this is not a problem that can be tackled until the stigma is fully tackled. These guys that people with that cannabis under, they're still classifying it as illegal. There's still a lot of old world views being held about being brought into question here. And I think until we change the stigma, or at least get it well known that cannabis is not a drug, we're accepting it more as a medicine, like was intended with the reclassification that still has not happened yet. Until we do that, until people see it in a different light and not as a drug that's been legalized to make money, which I feel like a lot of people do see it as, this cannot be properly tackled. The stigma is the old world stigma is still too much there.
Mm-hmm. Well, I mean, I think stigma is certainly a big part of it, but the hypocrisy of it. The fact is that it can be described to you in such an innocent way. Somebody taking a gummy bear two times a week for sleep makes them ineligible.
Right.
And I'm not like I don't own a gun. I'm not a crazy gun person, but at the same time, I don't oppose firearm use because I know that people overstep. You need to defend yourself.
Yes.
And don't even look at it so much as a gun right, and look at it as any constitutional right, because if they see you as an unlawful, illegal user of something, they can prevent you from doing something else. And so they're not saying if you drink alcohol, you fall in this position. They're saying if you take that's a poison. They're saying if you take a medicine, you're going to be in this position. And so it's pretty wild. Like this.
Well, did they actually say did either of them say medicine in there when they were discussing that?
Yes.
They did.
Yeah.
So I feel that's
the
a
stigma still attached to
but
it.
that's a sign of terminology changing, but people not realizing. Wait, I'm calling it a medicine, and they're in their head maybe they're thinking, oh,
because
well,
they haven't got to the medicine part yet in their head.
Exactly. It's if anything, I feel like the
Whether
most you get for for calling cannabis a medicine, you get social pressure of it. It's like, no, it's not a drug, it's a medicine.
I want to go back and challenge why you think you can deprive me of a constitutional right because I took an illegal drug. I want you to justify why that's allowable.
Well, the whole point of this case, Bill, is the fact that it's not illegal.
But Bill, I will.
Should you have to do a urine test before you vote?
I will.
Maybe we should check to make sure you're not using illegal drugs if you're voting.
I will play devil's advocate that a lot of those other things they're referring to have research, like coke, certain hallucinogens, heavier stuff, have recorded data that there is deterioration to the brain, which could lead to less sensibility, more rashness.
Aging does that as well.
But
so maybe we should challenge 70-year-olds.
Not the point of this. I mean, not that these are things that are irrelevant because they're relevant, but to this case, I don't think they're points of interest. What's points of interest in this case is it constitutional to ask people if they're an unlawful user of something that they're lawfully using?
But that's when you get at someone's mental state.
It is self-incrimination.
Yes. That.
Oh, wait a second.
And public safety.
Wait a second. Who's that? Is this my spiritual advisor?
Yea, and verily.
Oh, my.
Oh, snap.
It's Gandalf.
Where you come from?
Well, what's up, spiritual advisor?
Well, just wondering about this case.
Well, what?
The thing is,
Okay.
it bothers me and what has been said is they said, okay, suppose you're in Colorado and it's legal, blah, blah, blah. No, state law is irrelevant as far as the question of whether you have a constitutional right. A state can never impair your constitutional rights. Therefore, whether it's legal in that state or not is completely irrelevant.
That's a great point, actually.
You know, this is why he's in the field of spiritual advising.
And the other thing is, too, I feel like a very relevant argument in that regard is, that, like, yes, not as particularly relevant to this case, but at the same time, if you're going to have something that's legally available in certain states, you have to have some sort of cooperation of, like, understanding of, like, okay, just because I have to go on a business trip here and I bring my vape cart with me doesn't mean I should be looking over my shoulder every 5 seconds for police officers.
But and that's facts right there, right? That's facts. So let's keep playing this video. Wait a second, Bill. What do you think?
You have to do that with guns.
Quick note, don't go to Singapore.
No,
Or Russia.
I know.
Yeah,
That's not a place you'll leave easily.
Or North Korea.
Okay.
Bill,
That's even harder to get
Bill,
to.
real quick. Do you have an opinion, real quick, or we're going to keep playing the video?
Yeah, I forget what I was starting to
All
say.
right, keep playing the video.
Our position is Congress made a judgment in 922G3 itself that it is in fact dangerous to mix firearms with habitual use or addiction to controlled substances.
Congress made a judgment, not a jury, not a court, Congress. And that judgment alone strips the right. No individualized finding, no proof you misused the firearm, no proof you're violent, just status. And here's the cleanest admission.
That way, and
But
I
that would
think
be
we
your
would.
backup position. Your primary position is if it's scheduled in any way, so long as you use it a couple of times a week, you're subject to disarmament.
That is our position, and because of the combined effects.
A couple of times a week.
Who the
That's
fuck
it.
is this bitch?
That's the threshold. Use marijuana twice a week, you're subject to disarmament. That should bother you even if you hate marijuana, which I personally do. Because this isn't about weed. It's about categories. Now, here's where it gets uncomfortable for the government. Justice Gorsuch pushed back.
Habitual drunkard, the American Temperance Society back in the day said 8 shots of whiskey a day only made you an occasional drunkard.
What?
We have to remember the founding era. The founding era. To be a habitual drunkard, you had to do double that. Okay? John Adams took a tankard of hard cider with his breakfast every day. James Madison reportedly drank a pint of whiskey every day. Thomas Jefferson said he wasn't much of a user of alcohol. He only had 3 or 4 glasses of wine a night. Okay? Are they all habitual drunkards who would be properly disarmed for life under your theory?
That's devastating. John Adams drank hard cider every morning. James Madison, the guy who wrote the Second Amendment, reportedly drank a pint of whiskey a day. Thomas Jefferson drank wine daily. So let's apply the government's logic. Habitual intoxication, category, disarmed. Would Madison be disarmed? Would Adams? Would Jefferson? Because that's the historical tradition test under Bruin. And the government doesn't want that comparison. Now listen to what happens when the court suggests requiring real proof of dangerousness.
I think this is all the way down from G1 felons, every single category of felons. Even a serial murderer, you would have to be able to second guess. Is that person really dangerous? Is that a good proxy? How many people? What other kinds of offenses?
That's the fear. If courts require actual proof someone is dangerous, the entire framework of categorical gun bans gets exposed because right now it's easier to disarm by label. Felon, unlawful user, prohibited person, category first, rights later. Let's be clear, this isn't a case about someone waving a gun around while being high. It's about whether Congress can define you as dangerous simply because you fall into a legislative box. If frequency alone is enough, if illegality alone is enough, if a congressional judgment alone is enough, then the Second Amendment isn't functioning as a right. It's functioning as a conditional privilege, and the Supreme Court is now deciding how far that logic can go. Pay attention to this case, because it won't stop at marijuana. One thing's for certain and 2 things are for sure. Politicians
cut.
and tech giants.
And as a substance precedent, just as you know, it's not America. Winston Churchill would consume cocaine to get through the late nights of the World War. There's
Listen.
a long history.
Yeah, to me, it's not even comparable. But if it were, that is enough of a precedent for this to be proved as complete hogwash.
And even just on a general level, there's been plenty of court cases that have brought up the fact that times have changed. Times have changed, thoughts have changed, opinions have changed. They're just not acknowledging at all that factor at all to this. They're at least the people making the case are just not acknowledging changing times. They're willing to refer when these cases that they're referring to, the year that they were codified and whatnot, but not acknowledge, hey, a lot of times passed since then. A lot of opinions have changed.
They're just trying to hold a position that they've traditionally been holding.
I don't know, man. You work for the government. Obviously, you're doing the job that they want you to do, man. But to stand up there and fucking say the shit that they're saying, I'm glad I could hear this audio. I'm glad I can hear what the government is spending money on working on. This is what they're working on. And I say,
bullshit.
But I will say this:
par for the course.
Here's the thing: there's all this going on, but we see more states legalizing. We see dispos continue to run. And in my opinion, the country as a whole has seen this makes money. And if something makes money to that regard, we've learned that's pretty much okay.
Let's go.
Yeah. So I think there's going to be stuff like this going on. And people are going to freak out.
This is part of the journey.
It's here to stay, though. In my opinion, I think it's here to stay.
Yeah, just part of the journey.
what was that, Spiritual? Can you bump up Spiritual's audio here?
Are you saying you would legalize crack because there's money to be made in it?
Oh, no, shit. What I'm saying...
Ad gain.
That's not my personal moral belief. What I'm saying is the reading of the country. However, what I will say is that I think there is plenty of precedent for your body, your choice, and you bear the consequences for it. And...
Your body, your choice?
Yeah.
Dude, spit on that thing. Yeah.
You like that girl, don't you?
No, I don't.
Hey, listen, it's funny. I think that shit's funny as fuck.
But yeah, but there's plenty enough information about all this stuff now. Even fentanyl nowadays, the people who choose to do that, if you choose to ignorantly use something while there's information out there to educate you that hey, this is bad. Yeah, go ahead, do it. We have too many people in the world right now, and we're
all right. Do you have anything any thoughts on this?
No, I mean, pretty much made sense.
Dan, you got any thoughts on this?
I mean, really, my main concern was what if you're a cannabis business owner?
Mm-hmm.
Are you allowed to carry a firearm?
There's another.
Yeah, excellent.
There's security.
And that's it. And listen, that's a really good point because they can't even send their money to the fucking bank. So damn well a lot of these dispensaries are sitting with cash in their stores and shit.
Yeah.
And they're sitting ducks, and then they're targeted for that, and then the government targets you too.
In my opinion, the day can.
But again,
go ahead. Sorry.
There's a constitutional point. Your constitutional rights cannot be taken away without amending the Constitution. And there is a procedure to do that. And they did not do that when they came up with this law to say you lose your gun rights.
Yep.
Right on.
I think that speaks more to the
I think that's the bottom line.
Yep.